First of all, I wanted to thank you all for connecting on this Friday evening to this web talk, which I think it's super interesting, and I hope it's interesting for you too. So this web talk is, the title is Climate Justice and Human Immobility in Light of the Inter-American Court's Advisory Opinion 32, 2025. And my name is Beatriz Felipe Pérez. I'm a member of CICrA Justicia Ambiental, which is a cooperative which is located in Barcelona, and I'm also an associate researcher at the CEDAT URB. This web talk is part of the Erasmus Plus Climate Justice Living Lab project funded by the European Union. And in this project, the URB is one of the partners among other universities and entities. We really invite you to register and to visit the platform that we have created in the framework of this project, which is the Climate Justice Living Lab. We will share the website on the chat, which is very interesting if you're interested in climate justice. There are many resources and activities that you can follow there. So you are very welcome to register and visit that. I also wanted to say that we are organizing 2 extra activities in the following, at the beginning of 2026. First, we will have a winter school on climate justice that will be online. We will share more information later on. And also, we will also have another web talk in which we will analyze the advisory opinion of the International Court of Justice, also on climate change and the obligation of the states. So you are not focused on climate mobilities, but on a broader aspects. But I think it will be also very interesting for you, and we invite you to keep posted with all the things that we are doing in this project. So I'm really happy to share this web talk with 2 friends of mine, which I admire, and it's so interesting to have this time to talk to them. They are Marilia Gagliardi and Giovana Ginni. They are part of the I'm always saying that in Spanish, so I sometimes confuse in English, but it's the South American Network for Environmental Migrations. So I will introduce them very briefly, and then we will move just to the web talk itself. So Marilia, she's a lawyer trained at the Pontifical Catholic University of Sao Paulo and holder of a master's degree in public international law from the University of Sao Paulo. She works as a researcher at the South American Network for Environmental Migrations, RESAMA, focusing on human rights, migration, gender, and climate justice. And then we have Giovana Ginni. She's a researcher at the MAC Hub, focusing on transformation adaptation in the United Kingdom. Previously, she was an ESRC postdoctoral researcher fellow at the School of Geography and Environment, University of Oxford, where her work centered on the intersection of climate change and human immobilities. Giovana holds a PhD in Human Geography from Queen Mary University of London. She's also a member of RESAMA, and she engaged with regional experts in environmental migration. And she's also working a lot to create, or maybe I think she has already done, but maybe later she can explain about that, on a network of communities and initiatives impacted by climate change across Latin America. So, in this web talk, we will have time to discuss with Marilia and Giovana about the advisory opinion itself. We will discuss the challenge for active participation of the communities on this advisory opinion, and we will also focus on the legal implications specifically for climate immobilities. After that, we will have time for your questions. So please, I really encourage you to think about what you want to ask, to write that down, and to be ready to have a very insightful discussion at the end of the web talk, which I think it will be super interesting. I also ask you to please keep your microphones off during the seminar. And I also wanted to inform you that, as you know, this event will be recorded and published online afterwards. So if you don't want to appear in the recording, please refrain from turning on your camera. So that was almost all from my side, and I think it's time already to start with the web talk itself. So first of all, I wanted, because I know we have different definitions, we have different opinions even about what climate immobilities are. And I think it would be very interesting if you could explain us a little bit about what are we talking about when we talk about climate immobilities, very briefly, if it's possible.
Yeah, of course. I will try to make it briefly and also like clear. But as we know, climate change is impacting every single aspect of life and not no life as well. When I say not life, it's because it's impacting the sea, the land, the trees. Well, the trees are living beings. So, anyways, um, and as all these different aspects of our life and no life and are being impacted, also they also these changes are impacting or they might impact in the way we move, in the places where we can stay, in the places where we can live, right? And when we talk about climate mobilities or immobilities, we talk about exactly of the phenomenon of how climate change is impacting these mobilities when people move, because of the impact of climate change. And this is very tricky because climate change can be very evident in a mobile pattern, in a mobility pattern, like very easily to show is like in a hurricane. When you have an hurricane, you have people that normally evacuate certain areas, and that's a way of mobility. But also, climate change can be very implicit in patterns of mobility. That means that, for example, climate change will impact livelihoods, and then that will impact the economy or the livelihoods of the family, and that's why they will move. So it will be kind of hiding in between different other relationship, economic issues or social issues that are also at the same time impacted by climate change. I hope that that is clear. We talk about immobility as well, because sometimes people will choose or will be forced to stay in places that are not giving the condition for living in a dignifying way, if that makes sense. And I kind of want to highlight that some people sometimes that would be forced. People be stuck in a place, and sometimes it would be voluntary. So people know that they are living in a place that become very fragile, very exposed to hazards, but they decide to stay. That's very you can see it a lot in the Pacific Island states, that people are using voluntary immobility even not even as a strategy or as a option, but also like as a kind of statement. Um, and basically that's climate mobility and immobility in a short, in a nutshell.
Thank you, Gio. That was, I think it was very clear, and that you also were very well at describing how interconnections are working on climate immobilities and how also multi-layer and multifaceted are these movements too. And from that, I wanted to come to bring the web talk to the advisory opinion, because as we, or mostly we all know, we have been talking about the legal vacuum for so many years, about the protection of those people who are involved in these situations that Gio has just described. And here it's where the news, when the advisory opinion of the Inter-American Court of Human Rights came, they were like, wow, it's something great, it's just fantastic. Finally, we have some recognition. And I think that's why it's so important that we address that today, to get that clear what it really means and what does not mean. So I think it's important to remember that the Inter-American Human Rights System, in the Inter-American Human Rights System, the advisory opinions issued by the Inter-American Court of Human Rights play a fundamental role in interpreting and developing the norms of the American Convention on Human Rights and other regional instruments. So, understanding what's an advisory opinion and why this one in specific is so relevant help us to grasp the court's broader contribution to the evolution of the international human rights law, and in specific, we can say that on the protection, maybe in a longer time, of people affected by this phenomena. So, Marilia, maybe you can explain us what's an advisory opinion and why they are so relevant, especially in the context of Latin America.
Hi, Bia. Hello, everyone. First of all, thank you so much for this opportunity, for this space. Yes, I can definitely try to explain a little bit why this is so relevant right now, but I remain open for questions if it's not clear enough. So as you just said, Bia, advisory opinion, they are one of the key functions of the Inter-American Court because it does provide an option for a formal consultation process to which the court provides legal guidance to states or organs of the Organization of American States on specific questions of interpretation of the American Convention or other treaties. It can also be used to assess whether states' domestic laws or positions are compatible or not with the convention so far. So this is very important because it allows the courts to act in a preventive way, mostly, rather than waiting for human rights violation to occur and then to make all the due process of law to judge it. The advisory opinions enable the courts to clarify the obligations of the states, harmonize the legal frameworks that already exists, and guide states in the progressive development of human rights. It tells how states should act prior to a violation. So it's rather to prevent something bad to happen or to tell how states should act upon the situations. So over the years, we have like a lot of important advisory opinions on that, on freedom of expression, equality, and also environmental protection. And it did not quite just answer the legal questions, but shaped how human rights should work in each state. And this opinion, the 32 that we are discussing today, it was actually requested by Chile and Colombia in January of 2023. And the question to the court was centered on what are the obligations of the states to respond to the climate emergency that we are living on. And it's a very interesting process, this one right now, because it was remarkable participatory. What that does mean, it's pretty much that it has over 260 written submissions, more than 1,600 actors that participate, giving their opinions, the point of views, the repertoire to construct the advisory opinion. So we had states, international organizations, universities, civil society groups, indigenous, local communities, and individuals that shared their concerns, their perspectives, expertise. And we also had like 3 major hearings in Barbados, Brasilia, and Manaus, which encompass a large amount of land and territory that's being affected, bringing together more than 180 delegations. And after 2 years of analysis, pretty much, we have like this opinion this year on 29th of May. And it was recognized a milestone because, as you just said, we do not have a legal framework, but now we have an opinion of the court that has explicitly stated that climate emergency is a structural threat to human rights, and the states have a directly legal obligation to address it, even without a specific treaty to it. So it recognized pretty much that the states have the duty to prevent reversible, that's a difficult word, environmental damage, and has a set of cautions, which pretty means is that international law cannot be derogatory. So it must be complied to. Every state should take note, they should work to prevent the harms of climate-induced consequences, one of them being involuntary mobility. So this decision is historic because it positions human rights as the center of global response to climate change. And in doing so, pretty much it reaffirmed the relevance of its advisory opinion, because the first time that American courts like, okay, there's no treaty for that, but the states need to address it. And they need to take care of mobility and immobility, what we can talk a little bit further after.
Thank you, Marilia, for this introduction to the advisory opinions and the relevance. And you were just mentioned that it was highlighted the relevance also of the very strong participation of different entities and also many NGOs, many indigenous peoples from the grassroots organization, also from academy. And in this sense, yeah, it was highlighted that there was an unprecedented level of participation by civil society, right? And then I wanted to ask Gio, maybe you can explain a little bit further on that, because why it was so important. There were so many people taking part on the consultas to the advisory opinion, which were their main demands. And I also wanted how this influenced the results of the advisory opinion. And also, I've also heard that there were many challenges too, and that not everybody was able to take part on the process. And maybe if you can explain a little bit on that, I think it would be super interesting.
Yeah, of course. Thank you, Bea. Yeah, as you both say, it was a historic engagement of the civil society in the 45 years of the history of the court. And why it was so important. So the first is that it gives the process and the advisory opinion a legitimacy. The climate crisis, as I hope everybody knows, disproportionately affect those that are more marginalized, and also normally these that are more marginalized are less political represented, are less represented in political spheres, like in diplomacy spheres. And these people are, for example, indigenous people, Afro-descendants communities, rural farmers, and coastal populations. And the direct participation in the through the written statements or through the audience, it was very important because it kind of ground the court's deliberation in the realities of those that live the climate crisis, right? So it's not, they have like the first kind of the experience, the experience of the crisis in their own bodies, in their own cultures. The second point is that they brought this plural form of knowledge, like something that, if there is something amazing in Latin America, is this plurality of knowledge and way of living and way of understanding the world. The civil society actors submit local impact assessment, indigenous environmental practice, and testimonies of forced displacement and immobility, that inability of some communities to more even that they anyway. So sorry. So every single different actor of the civil society presented different aspects through their own lenses, through the old way of through their own knowledge and systems. And the third is that it oriented the conversation from the environmental protection. Is something that what Marilia was saying, that it didn't stay, the conversation didn't stay in environmental protection, but went to speak about climate justice. And I think that that's very important. And many of the claims from the civil society were around structural inequalities. So recognizing that climate change is an environmental issue, but the impacts are political, that they're embedded in the structure of that creates inequality and marginalized people. Colonial extraction, not only structural inequality, but also colonial extraction and human rights. And that kind of shape a lot, I guess, the result of the advisory opinion. The demands of the civil society were many. Maybe a way of putting them together is like in these 6 points. The recognition of a right to a safe and stable climate. The binding obligation on the states, the need of a binding obligation of the states. The human mobility and immobility, presented for like this idea of the recognition of climate-related displacement and the rights of those who cannot move. So the rights of people who are in the move or who will move, and the right of people who are not moving or they can't move or they want to move. There was a lot of calls for humanitarian visas, no refoulement guarantees, and planned relocation framework. The procedural rights were also a main topic. Procedural rights are basically at this process of consultation that it says that people that are affected by decisions of the state needs to have information, a guaranteed participation and access to justice. The protection of environmental defenders were also part of the demands. As you know, 70% of killing of environmental activists worldwide are happening in Latin America, and that's very important. And some countries also, some civil society actors also echoing Ecuador constitutional provision and Colombia jurisprudence are the calls for right of nature and intergenerational justice. So how that influenced the advisory opinion was perhaps like, I think that it is kind of all over in the civil society, in the civil society imprint is all over that advisory opinion. But if we need to say like where you can see it more clearly is in the Declaration of Climate Emergency, in the state obligation, the state obligation not only between their borders but also beyond. The procedural rights, again, that is like the information, participation, and guarantee of the guarantee of the process. The dedicated part on climate-related human mobilities and immobilities, and also the recognition of the need for the protection of environmental defenders, if I need to choose. And as you were saying, the main, just to close in, because I don't know if I already spoke, but to close it, like the main issues facing by civil society is like the resource inequality. As Marilia was saying, there were like two public consultation, one in Barbados, that who doesn't know who is Barbados, is in the Caribbean, and the other one in Brazil. Many grassroots organization or indigenous group normally will lack funds to go to these places. We'll also lack the funds to prepare legal submissions, because the writing statement that you submit for the advisory commission, it needs to be, it needs to be put it in paper, basically in the language that perhaps some grassroots organization might be lacking. The language barrier, most of the things were happening in Spanish. As you know, most of the Caribbean speak French or Creole, and obviously Brazil Portuguese, but then indigenous communities, sometimes they use Spanish as a second language and not the main one, and there are also like language barriers. Representations, that's more related to the internal issues from the organization, who will go if you don't have enough fundings, etc. Security risk for environmental defenders. The limit procedural weight, meaning that even if you went there, you spoke to them in the public audience, you wrote the paper, there are no guarantee that knowledge will be used, right? And the technocratic complexity of the whole process. And also on the language. I will say language again is in the terms of climate science evidence, that sometimes I wasn't part of the public audience, but I know that sometimes the judges were asking questions that were very technical, and that also like kind of create that distance between what is like local knowledge and just knowledge, and how and the lack of translation, or the lack of sympathy in between understanding issues in different language, not only in language itself, but in different way of speaking about these issues. So yeah, I think that I will close it there.
Thank you, Gio. It was very interesting, everything that you've said, especially how this access to justice in this specific case was really difficult also for the grassroots entities. Even if there was a very high participation, I also find that it was very hard, not only because of the climate science, but also on the legal language too, that it was asked to be done. And I just wanted to highlight that at least it was interesting, and also following with the next part of the web talk, that I found that it was very sensitive from the Inter-American Court of Human Rights to at least specifically have one question on climate mobilities, that we don't have it at the International Court of Justice. And that specific question, I think it was so relevant that it really opened a door or a window to have a lot of things that now I will ask to Marilia, because I think it was said that it was a landmark development in the human rights system, particularly in addressing the emerging nexus between climate change and human mobility and state obligations. And this is something really relevant, I think, because Marilia, well, I will just ask you directly. How does the advisory opinion advance really in the legal recognition of climate-induced displacement within the Inter-American human rights system?
Hi, hello. First of all, I would like just to agree with you, like this process can be very excludent because of all the barriers that it has. But something that was very nice in particular on the material presented is that some materials by some organizations, such as Nuestro Futuro and Greenpeace Mexico, they brought to the court some extracts of speeches of people that have been displaced. So they put their experiences and how they are being impacted in different segments, which I feel that had a clear impact in the opinion that I'm going to further now. But just because when they were like presenting the case, they made mention, they were like, well, considering these people that were displaced. So they read this kind of very touching, actually, speeches that people gave on being displaced because of climate change, because of environmental reasons. So something that the opinion builds upon is the rights under the American Convention as like rights to life, personal integrity, property, residence, freedom of movement, health and environment, and they interprets them in a way that encompasses climate-induced displacement. It says that the right to freedom of movement should include not only the right to move and seek refuge, but the right to remain in a safe place, remain in a place with dignity, with human rights guaranteed, being protected by being forcibly displaced. So it's pretty much saying like people should move if they want to. They should have this in a safe way, but they should not have to. So the court, it does bridge a gap that we had so far, which is like the duty to protect the environment within the duty of protecting the movement, because we have a lot of different opinions and like treaties so far that does protect it individually, like they were not connected parts, and the court does connect these two elements. It places displacement within the logic of the state responsibility under international human rights law. And it also stresses the protection of displaced people cannot depend whether a specific treaty exists or not. They're very clear on that. They are like, all the rights related to this mobility are already protected by the state. So when someone says like in the deployment something like, well, I had my mental health destroyed because of being displaced, they're like, well, this is already protected, so we don't need a new treaty to demand the states to cover it. So I feel that that's the significant step that the court pushed in this advisory opinion.
Thank you, Marilia. And I just wanted to add regarding what you first said, and also to Gio's intervention, that I also find very interesting the website of the advisory opinion, where you can visit the hearings and you can read all the papers that everybody sent. And I think that they work on a transparency exercise in order to have everything there and very accessible to everyone. So I don't know, I find it super interesting, and we have just shared the link on the chat. If you're interested, you can also go there. And coming back to the legal aspects of in the steps forward of the advisory opinion on human mobilities, I wanted to ask you also, Marilia, which are the key human rights obligations of states which are identified in the advisory opinion, in specifically related to human immobilities? And I get it together with the following question, if it's okay with you, because I wonder if you could explain us a little bit if this advisory opinion creates any new standards or preventive measures by states to avoid displacement and how it does it.
Okay, I'll try to address both of them. So the opinion, I feel that is pretty easy to see that the opinion does cover three main pillars, we could say. So it does establish the duty to prevent. So it says it must act with due diligence to avoid violations that are foreseeable violations of human rights caused by climate change and environmental degradation. So adopting legal and administrative measures, budgetary measures, reduce exposure and vulnerability to climate risks, it does impose that to the state. So you need to act to not make people more vulnerable or like to reduce vulnerabilities that already exists. It does also establish the duty to protect. So they say that people that are displaced or need to migrate, so cross borders, they have guarantee access to essential rights, such as housing, health, food. So it means that, okay, if the disaster happened anyway, if these people are displaced, they should be assisted during this time, during this crisis, during this human rights violation. And I feel this is very important because it does focus on indigenous people. The court does take a lot of steps on like making concessions focusing on indigenous and traditional communities, as if it recognizes the special bonding that they have to land and territory. And they say that the states have the obligation to provide land of equal quality and legal status to ensure cultural continuity and community, which means it's like you cannot see some people that have like a deep connection to the land being displaced and be like, well, okay, let's just put these people in a city center and they are going to be fine, because it needs to recognize like the culture, the religious space that they occupy and all of that. So this is an important step that I'm sure Joe is going to explore further. And we also have like the duty to cooperate. That's a very interesting point because it stressed that climate change is transboundary, which we already know, right? It's not going to stop at the border of our country. So it does require that the states work together. And it says that the states within its framework needs to coordinate to ensure that displaced people are not returned to unsafe conditions. So it does say in a very weird way that we can go deeper that there is like no reforma. So the no devolution principle, if people are to be put in danger of being returned to a place that's environmental degraded as well. So they encourage to create humanitarian measures. So it places quarantine thus people under three pillars situation. And regarding the new standards, I would say that it does not create a new standard. It just utilizes what we already have. So the court its mandate is interpretive. So they are like, well, with the rights that we already agreed upon, the states have some obligations. And I think it's well seen the concept of planned relocation because it sets some principles such as like relocation must be exceptional, it must be planned, it must have participation, it must ensure continuity, and must be dignified. So we need to guarantee house, education, healthcare. People need to have a transparent process of that. It needs to be planned, so people need to be able to join, to take a part in the decision, to understand where they are going to, if it makes sense for them or not. And it does also call states out on having to develop early warnings and monetary systems. So people need to understand that they are going to be impacted. So it cannot be a late response. It's pretty much as like it does not create again, it does use the framework that we have, but says like states must ensure that people are not caught off guard and lose everything. They need to understand what's going on and they need to have like alternatives to build upon. So I feel that it does transforms what we have as like protect the environment as something like people are right holders if they are affected by environmental crisis, and we need to understand that the environmental and people are not disconnected, and that's some ways what in which it can be done. So that's what I feel that the opinion does.
Thank you, Marilia, for this analysis. It's so interesting because also some analysts have said that there are new standards and so on, but I agree with you and that what it says is just reinforcing that we have to use what we have for those affected people. And I think it was also needed, and well, I hope it will be used in the short term. And regarding also to that, I found that it was also interesting that the court didn't really mention how international frameworks as the International Convention on the Protection of Refugees and its protocol, the New York Protocol, and the Cartagena Declaration should be specifically applied. And I found very interesting when I read the blog post that you publish in the RESAMA website that our colleague Alejandra just published on the chat too, that you analyze exactly how the advisory opinion 32/2025 is related somehow to the resolution 224 of the Inter-American Commission on Human Rights. And I was wondering if you can explain a little bit that, because I think that unfortunately this resolution is not that famous, and that if you only read the advisory opinion, you are missing a lot of details that actually were already there. So if you could explain that, that would be fantastic. Thank you, Marilia.
Of course. No, yeah, I've just shout out that this blog post only exists because I did a very nice work with Inacio that's not here today with us, and because Gio here actually posted, because she's the one that coordinates the blog. So thank you, Gio, for that. So yes, we do have like this resolution of the Inter-American Commission that was issued in December of 2024, and it also does address the human rights and climate-induced human mobility. And I feel that while the advisory opinion provides a legal interpretation, the resolution provides policy and operation guidance. I feel that it does complement where the advisory opinion sometimes lacks. So while the advisory opinions is like, well, if the state should not need to return people, they need to consider if it's environmental safe or not, using maybe refugee status. But that's not very precise because some states do not understand that people displaced by climate or by environmental should be treated equally as refugees because of a lot of normative talk that I don't think it fits here. But so it's kind of in the open. So it's like you should not only do like this devolution if it has a humanitarian reason already specified or not. And that's where the resolution fits in so well, because it does elaborate concrete measures that the states must adopt. So there is like a collection of disregarding data on displacement. They're like, well, we need to have more precise data. We need to do early warnings in such a manner that it does create a system and humanitarian protection mechanism. So it's very more like specific. It does give us how we should apply this understanding of the law, and it does, I feel that reaffirms in a very better way the non-refoulement principle. So it does say like, well, if people should not be returned with or without a legal framework. It kind of falls under the umbrella of humanitarian response within the advisor opinion, but with the resolution, it does clarify a lot better how to deal with that. And it also clarifies that climate-related factors can interact with other violences. So it does say like climate-related events can create persecution or violence or give rise to what we consider actually like under international law refugees, and how it does actually indicate how it fits within the Cartagena Declaration and how it's pretty much all connected if we have like a broader understanding. So this interpretation feels like a critical gap, I feel, that was left by the advisor opinion because it could not cover everything. It's a big resolution, but it does kind of, I feel, that give on tips on how to follow and how to proceed. And yeah, I do feel that it also has count upon a lot of very interesting outputs by scientific and scholars that can also be assessed. And it's a very interesting material. I will keep talking right now because otherwise I will just go on.
Thank you, Marilia. I'm sure there will be more questions regarding this in the public question time. But I wanted to ask to Gio, if you could explain us like a real case of climate relocation or climate displacement, and then how do you think that this advisory opinion or the outcomes of it could be useful for them or not?
Yeah, perfect. Thank you. Thank you, Marilia, as well, to set the ground. So I will explain a little bit of the case of Enseada da Baleia, that is a community with who I have been working since 2019. Enseada da Baleia is a traditional community. Traditional communities are they are not indigenous, but they are very similar in terms of rights. No, they have a specific culture separated from the main culture of a country, or in this case Brazil, and they should be protected for the culture and the way of living should be protected in terms of no forcing them to quit or to change, if that makes sense. So they live in ZWA as one or of seven Caiçaras communities in an island called Cardoso Island in the southeast coast of Brazil in the state of São Paulo. They have been suffering erosion for for a long time. And erosion, and then also like frequent storm and the sea level rise, sea level rise. And in 2016, with the storm, they lost 12 meters of land of the island, that basically left only 2 meters between the two sides of the island. That is, one side is the estuary that is near the mainland, and the other side is the Atlantic Ocean. Back then, they asked for a relocation to happen. They live. The Cardoso Island is a state park. That means that is under a protection scheme of the state, right, to preserve nature, etc. And that's why the land where they live is not legally theirs as well. That creates other sort of issues. So they asked for being relocated inside the island because they have been living in the island for almost 200 years. It's their home, it's part of their culture, it's part of their identity, it's part of the livelihoods and income generation activities, etc. Because of being a conservation area, the authorities of the park and the state offered them to be relocated outside the island, near a city, as Marilia was saying. As an example, and then when Enseada say no, we don't want to go out, they say, so you can go and join one of the other communities inside the island. That is also a way of violence, and also like seeing not only like violence in terms of seeing people like different communities as the same, right? So if they're all cases that are the same, but also like it can create a lot of conflicts and tensions between different communities, right? Because every community is different, and if you just bring a whole community inside another one, that can create issues and can also transform no in a good way, internal way of doing stuff, way of governance inside the communities. Back then, 2016, they activated, the community activated the defense, the public defense, basically using another international convention, that is the ILO, International Labour Organization 169. They managed to invoke the right to be protected as part of a traditional community, as being a traditional community, and eventually the relocation was approved by the authority of the park. However, they didn't give them any sort of financial support. That obviously we're talking about a community that the main activity is fishing, so it's very precarious in that sense, in financial sense, and that and then the need to relocate with that kind of support, or with the lack of support, was very heavy on the community, in terms emotionally speaking, financially speaking, and physically speaking as well, because of the labor implicated in take your house from one place to another place, right? The process of erosion and the storms are still increasing in the island, and today the community is facing the risk of a second relocation because of the erosion. And now it's not only in CEDAT, but it's also other communities in the island that are also feeling that need, or recognizing the fact that they might need to engage in relocation, right? In terms of what the advisory opinion gives to these communities, so the first one is like the state duty to protect against climate harm, right? And that also includes sea level rise and erosion. That means that in the case of the relocation, right, in the moment that in certain areas to legally fight for a relocation, the state was, breaching this duty. Not only the duty to protect life, housing, and culture. Then the fact that I think, and Marilia can correct me, the fact that planned relocation is seen as a human rights measure that needs to happen only as a last resort. That's very important, because means that it's not the decision. It's not like because the committee wants to, but it's because they need to. And I think that that's very important to highlight it. One of the things I forgot to say, when the authority of the park give the land or authorize the relocation, they asked them to reforest the area that they were living. That today that area is underwater, but it's in this is but the way I see the fact that they were, okay, we are going to let you relocate in another place, but you will need to plant trees where you are living, is that they saw this process as something that, like a wish of the community to relocate, and not as a need, perhaps. And I think this thing of seeing plant relocation as a legitimate resource and adaptation strategy, it gives communities more. It opens the window to have your rights respected, and to make this process more inside, as a dignifying process. I don't know how to say it properly, but and then obviously once you are talking about human rights and planned relocation and human rights, it means also that it needs to be voluntary, or at least in participatory and collaboration with the people that are affected. It needs to be culturally appropriated, and that is very important, because it means that the people will have that you don't need to invoke a international convention to make institutions on the state's institution to make them understand that the way you live is very much related to your culture and your identity. So if you just pick a community and put them in the middle of a city, you are causing so much loss and so much damage, right? The procedural justice, that's also like super important, because again, I'm repeating a little bit, I guess, but this idea that, okay, we cannot just force community to relocate, but it should be a process of collaboration, participation, and collective decision. And another, the cultural livelihood, again, I'm repeating myself, and also something interesting is like the differentiated responsibility and equity. The fact that the most vulnerable communities, or the most marginalized and precarious communities, are seen under the advisory opinion as a special group that needs a special protection. So I think that differentiation to make possible equity is very important. Yeah, and the potential benefits for CEDAT itself will be like the legal recognition of the plan relocation as a strategy, access to resources, the guarantee access to resources, the guarantee respect of their culture and identity, the guarantee value of the work and their participation. Yeah, I think more or less that. If it makes sense. I hope that it was clear.
Thank you, Gio. It was very clear. So now we have time for questions from the audience. So I invite you to raise your virtual hand and do your question through the microphone or even with your camera. And if you are shy, you can also write them down on the chat. I think that there should be many questions, so please don't be shy and ask them. In the meanwhile, I wanted to ask you both about we are in las puertas of COP30, which is about to start next week. And I was wondering what's your opinion and if you think that there will be any positive outcomes of the agreements regarding somehow mobilities. I see now that we have some questions, but maybe we can recall them and ask them after this. Regarding the COP, what's your opinion about that? How is it, especially from, I think, Marilia, you are in Brazil now, and Gio, you were there until recently. So from there, maybe you can tell us your experience about that.
So I feel that this COP has a lot of noise about it because of the accessibility to civil society to join it. People said that it was very exclusionary. However, we see the presence of a lot of like civil society and NGOs participating and demanding already rights for young people to traditional communities. So I feel it should be interesting. I'm not sure if you're going to reach some kind of agreement, but I know there is a lot of pressure of people that are demanding to be here right now. So I think we have space to construct something very nice. I'm not sure if we're going to reach it though.
Yeah, I guess that it will be a little bit of a weird COP, because there will be like major players that are not coming, like the US, India, and China, I think. So that will be interesting also to see globally who will be trying to become like a leader. I think that the UK is investing a lot in the COP this year. Like you have Prince William, etc. So maybe they will be like key players. In terms of climate mobilities, I think that there will be a lot of talk about adaptation. There is like the global goals of adaptation that they need to ratify or agree on something, and maybe that will be and migration in the literature at least is recognized as a adaptation strategy. Um, However, not necessarily by states. Like there's academia recognized it like long time ago that adaptation, that the migration or mobility can be used as a beneficial tool for improving the life of people, even in the condition that sometimes is forced. But some states, they keep on seeing migration as an issue, particularly when it's like from the global south to the global north. So let's see what kind of conversation or negotiation are around migration inside the framework of of what adaptation is, right?
Thank you both.
And I think that Marilia will be there, so I guess that we can keep on following her and see what she
Sure.
posts in the next couple of weeks.
Sure, it would be so interesting. And I see that there is one question. So Joyce is asking, are things stand we still do not have legal recognition of climate refugees? Like the way refugees are covered under the 1951 Refugee Convention, what does it mean for litigation as things stand? I mean, maybe Marilia, you can try to answer this question.
I feel that's a more legal one, so I can try a little bit. So we do not have like a legal framework recognizing the category of legal climate or environmental refugees. What we have right now as a matter of international treaty regarding refugees is pretty much the ones that face prosecution. What we do have in the Americas, however, is the Cartagena Declaration that does encompass that people that are fleeing also humanitarian violations of massive humanitarian violations can be included. But then again, what are these massive humanitarian violations? It's kind of upon the states to decide. We do have like a review of this convention every 10 years, so we call it like Cartagena plus 10, Cartagena plus 20, Cartagena. Now we just settled the Cartagena plus 40 because it's been 40 years from this declaration. And we do talk about climate change and we do talk about environmental aspects. So yes, we do kind of have the understanding that this could proportionate some kind of protection for humanitarian approaches. However, it is not how can I say, internationally worldwide binding, and not even like in the Americas. It could be invoked, but it does not demand that the states like create a legal framework right now to establish that. So in litigation, it's not so easy to evoke that. What does happen in litigation so far is that we evoke other treaties. So if we see like the displacement that happened, like the people that were demanding to be recognized as refugees, climate refugees in like New Zealand, they were actually claiming on the civil and political international treaty. They were using like the 60 amendment because they were like, well, I do have the right to a safe life. However, we do not have a treaty for that, so I'm going to use another one that does guarantee me to live safely. What the advisory opinion does provide is pretty much saying that the International Convention also have all this framework that does guarantee rights to people that are being displaced. So it's pretty much saying like you already signed upon rights that should encompass climate migrants, climate displaced people. So we do not need to create a new thing, but it does not exist so far, the climate refugee status, because it's not recognized internationally so far.
Thank you, Marilia, and congratulations for resuming all of this in a couple of minutes, which has been so difficult to do. So thank you for doing that. And I see that we have another question from Professor Justo Corti Varela. And well, I take advantage to also say hi to Justo and welcome to the webinar. And his question is, if you want, you can ask it directly. No?
I'm too shy, please.
Okay, then I will ask it for you. So Justo is asking if the advisory opinion or any statement made during the proceedings address how to identify climate mobility or immobility, particularly considering that in the vast majority of cases, it's a multi-causal process. This is a very tricky question. Well, I give you the floor to answer. Maybe you have some answers, Marilia, Gio.
Gio, do you want to start? Then I compliment?
I will try, because it's kind of a tricky question. Like, I don't think so, because migration in general is multi-causal, right? Climate change or environmental factors, they just add up. Most of the time, there are places, when there is a sudden extreme event, is very clear with climate change, or very clear. It depends. But let's say that it's more clear where environmental factors are playing a role. What the advisory opinion does is that it reiterates again that climate change interact with pre-existing social, economic, political, and environmental factors. Meaning that it's almost an illusion to try to identify climate change as the main factors, or even like having like this formula of like, okay, this is climate migration, this is no climate migration, right? Which the the separation of who is an economic migrant for calling for a wage, and who is not an economic migrant, or who is an environmental migrant, or climate migrant, is very fictional. I'm guessing. Yeah, I think that's I don't know if that answered the question. Like,
Let me reformulate a bit my own question. But I agree with you in theory, but the legal framework is completely different, particularly when we talk about international migration. We have on one side a regulation for climate migration, and other completely different, particularly if we link climate or environmental migration to human rights for this second position. I mean, I agree that the distinction in practice is very difficult, but making the distinction has legal consequences.
I feel that there is an answer that's not very satisfying. But what we have so far is pretty much that when there is like a disaster, well, I'm not going to say like environmental disaster, because we do not believe on that. We do understand that if there is a disaster, there is a lack also of political will to make this place resilient and not so vulnerable. But if there is a disaster, it's easy to identify. So if it's massive, I feel that this is going to be encompassed and understood under international law in a much easier way. So like in Brazil, we have like droughts from like the Northeast region like every year, and this push a lot of people to go to other states. And that's not really talked about as a climate migration. However, we do understand that it is, because it is not so big, or it does not have like a very impactful start. However, when we talk about like the floodings that we had also in Brazil, in Rio Grande do Sul, everyone was like, well, okay, so those are climate refugees or climate migrants, because it was such an impactful thing that happened that was very easy. So what I feel that's probably going to happen in litigation matters is that it's like, if you have like a disaster, you have like something very big, is going to be easy to be identified, and under international law is easier to be recognized. However, if we are talking about like slow onset events, such as like salinization or like things that are not so easy to identify, it's still going to be like a dispute under juridical analysis, or even technical ones. That's going to be like, well, is this going to be related to climate disasters or not, climate movement or not? So I feel that we are starting to enter in this dispute right now. But I do not have like an answer so far, because we don't have decisions so far on that. But that's how I think this framework is going to work. Jill.
yeah, I just want to add that the majority of people that that move because of climate change are internally displaced or internally migrations or whatever you want to call it. I think so also like there is a lot of, you know, if we are going to start speaking about climate refugees or as a legal category, we will need to reframe and perhaps reconceptualize what refugee means, right? And that can be very dangerous as well, considering the right of refugees that are fleeing mainly internationally. So I think, you know, I think that there is always like more questions than answers in this case. But also like, no, just highlighting most of the people moving because of climate change are internally, as Marilia say, a lot of them are invisible because there are no data on them and are mostly or because of slow onsets events like draws, etc. And perhaps what we and perhaps that battery opinion, like one of the major contribution is trying to make states more accountable for their own citizens, rather than thinking about like what to do with people from other countries or camps, you know. I don't know. Yeah.
Thank you both, and thank you, Justo, for your question. And also regarding to what Gio was saying, we have a question from Suelen Araujo, and it's asking that given tightening migration policies in some countries, as we were just also, we should comment at some point, to what extent might states undermine international protection for people displaced by environmental disasters? How could the advisory opinion number 32 2025 help guide more protection in this context? I think somehow we have answered this question during the seminar, but maybe if you want to highlight some key points or something, that could be nice.
Yeah, no, I do feel that the opinion does push states to like create preventive measures. So I feel that what I think it's like the biggest gain is being like, well, states should not just react to climate induced movements. It should also have like preventive measures to deal with disasters if they're going to happen, to know how to conduct people that are on the move to protect themselves from environmental and climate situations, and what should be done with people that are affected. So it's like create plans. From Brazil specifically, we do have like a lot of projects that's running right now. We have like the first approval, but it does remain to be seen. It's one proposed by Erica Hilton. I think is worth to take a look because it does also comprehend a lot of protective measures. So in some way, it is in line with this push of the Inter-American Court. It does say like, well, we are also trying to be held accountable, and we are also trying to create measures to prevent it from happen. However, we know that laws doesn't actually help if we do not have a lot of investments to make the policies work as well. And what I do feel that the legal opinion, advisory opinion does say is pretty much like, you need to be prepared. You need to put like financial matters into it. You need to put policy measures into it because it is happening. So the court is very clear on like, it's not if it's going to happen, it's like it is happening and you need to take care right now. So, and also just like a matter of like international law geek, it's not binding. This opinion is not binding, which means that it's not mandatory that the states use it. However, we have like previous decisions by the court in sentences that are like, in good faith, you should have utilized this advisory opinion. So it's like, okay, it's not mandatory, but you were aware of it, so you should actually have done it. So we do have an understanding that it can be quoted maybe in advocacy procedures inside Brazil, as well as Argentina, Chile. Like it could be evoked to press the government. So it's very much on how it's going to be utilized. But it can. It's not mandatory. They are not like going to use it as a law, but it could push and put pressure into measures that should be implemented.
Thank you, Marilia. So I don't know if there is like an final question or any thoughts you, Marilia or Gio, want to share before we finish this web talk. I think
I
we're
feel I
all
talked
good.
too much so far. I'm sorry.
No, it has been super interesting. So if there are no more questions and you don't want to add anything else, I think we can close out this web talk for now. But it's I hope it's an open conversation and that we can still have more spaces to continue seeing how this the advisory opinion develops. And also, it was just published in July, so I think that there is still a lot of judicial decisions and many other outcomes to come. So maybe in a while we can see how it really worked or not. And yeah, to finalize, I just wanted to say thank you, especially to Gio and to Marilia, because it was super interesting to hear both of you. Thank you so much also for the audience or everybody who was connected and registered for this session. Thank you also so much to Alejandra for her technical support to this web talk. And to finalize, I just also wanted to kindly remind you that we have this platform on Climate Justice Living Lab, and that would be fantastic if you take a look at it and you register, and then we can keep in touch and share more information on the next web talk that will be taking place at the end of January, and on the winter school that it will be online, and it will also take place at the end of January, beginning of February. So thank you so much. Have a lovely weekend and enjoy it so much. And well, that's all from our side. Thank you.